On State versus Ward. Mr. Ward and his attorneys are present. State's attorney's office is present. This is the final jury charge conference. Let me start by focusing on the tenancy by the entireties, since that seems to be the one remaining issue. The court has sent to both of you the case of Truett, Truett versus State, 10573 656. For clarification, I merely sent you the site. If you look at head note 6, if either side requests a jury instruction that is a correct statement of the law, and this has become an issue in the trial, it is considered error for the court not to give the instruction. The tenancy by the entireties was raised by both parties, was raised by the defense, both during its opening and during testimony in the case. Your expert on this issue, Professor Davis, misstated the law in one case and was a little bit confusing on the other point. I don't think he ever misstated the law. He just didn't know anything about it, and the whole thing became confusing. The state is requesting an instruction to clarify the law in this issue, and I think they are entitled to it. Mr. Braven, do you have any further argument to make on this point?
Yes, Your Honor.
Go ahead.
Under the case you sent, Truett versus State, at head note 6, and I've read, literally, we're deciding how to describe probate law to a jury in a murder trial. And I've read it for 15 seconds, but I can already tell you that on 2 of the 3 points upon which a requested jury instruction must be given such that it constitutes reversible error, it has to accurately state the applicable law. This doesn't, and I'll explain that in a moment. And it has to be supported by the facts of the case, and this isn't. There is no fact in this case that Mr. Ward was aware of any of this at all. And as Your Honor explained, Jeffrey Davis did not misstate the law. Also, to Mr. Jay's point earlier this morning, that he didn't have time to find and call, excuse me, an expert on these sorts of effects, he didn't ask Elizabeth Green any questions about this. And that had nothing to do with the scope. She testified that she was a professor, or at least an adjunct professor, taking over for Jeffrey Davis's class. This is an evidentiary point, and it's a lawyer's argument to make, okay? The law that's stated in the state's suggested instruction and included in your most recent version says the following. And I'm reading the beginning of the second paragraph. However, under both Florida and Georgia law, and no one in here has any idea about Georgia law, if the surviving spouse unlawfully kills the deceased spouse. Now, I was admonished by both the state and the court for the paragraph 5 of the law, which says that any degree of murder. Well, an unlawful killing can include manslaughter, and this includes it improperly. And so the law says intentionally and unlawfully.
Well,
okay, and
that goes to how I worded it.
But this goes to the danger of trying to include a probate section in the jury instructions. It is not supported by the facts of this case. If Mr. J makes the argument—
Let me interrupt you here
yes,
one second, Mr. Braven. Are you telling me that the defense is not going to get up and argue that tenancy by the entireties and how the properties were held means that Mr. Ward had no motive to kill his wife?
No, Your Honor. But I'm also telling you that we don't need—
you concede that that is going to be one of the defense's arguments?
Yes, but
Okay.
we are also not going to get up and say that tenancy by the entireties protected all of Mr. Ward's assets, even under this statute. And the evidence that's been included and admitted in this case, at least $4.6 million would have been protected if Mrs. Ward stayed alive. The rest of it would have still been protected so long as Mr. Ward were not proven to have unlawfully and intentionally killed his wife. To put in front of the jury a statute that presupposes an unlawful murder in a case where we're deciding whether this is an unlawful murder is entirely inappropriate. If Mr. J argues this, it is just a lawyer arguing the facts of the case, what someone said the law is versus what someone else said the law is. If you tell the jury from the bench what the law is, you are risking Mr. Ward's right to a fair trial and jeopardizing this trial. I have been intimately involved for 4 years in trying to undo mistakes that were made in the last trial. It shouldn't and can't happen again. And over a jury instruction, it will be one of many, many, many points that Mr. Gillen makes. And it doesn't have to be. Mr. J is also free to argue that they had a lot more money. He's already raised several properties that were titled in each of their individual names. I understand Mr. J wants to say this didn't protect all of Mr. Ward's money. It was a protection of some. We said 9.2 million. Now with this statute, we're down to 4.6 million. The point is the same. $4.6 million to me is still a lot of money, and it still provides a lot of protection. This being a jury instruction is a mistake, and I don't think you should be diverted by the fact that Mr. J asked a witness about 2 statutes. He didn't ask for the court to take judicial notice of the statutes and admit them into evidence. He's asking you to give an instruction to the jury on this point. I think it is reversible error to give the instruction, especially with the misstated law.
All right. Is it your position that the 2 paragraphs that I proposed are a misstatement of the law?
I have to go back to that, Your Honor, excuse me. My computer is saying whoops when I try and look at it. Let me try one more time. Yes, Your Honor, I am.
That it is a misstatement of the law?
Correct.
Where is the misstatement?
It's at least it's at least unknown to any of us what Georgia law is.
I'll grant you that one.
It is also.
We're going to take that out. I'm going to take that out.
I cited it in my memorandum. There is a statute that says the exact same things.
Well, I understand that, but for a Florida judge to instruct a jury on Georgia law is...
They've been talking about his Georgia assets too, though, haven't they?
I didn't say you couldn't argue it, but there's a difference between me instructing on
Also,
a law that I'm not aware of.
and the predicate for any of this, and I think it's an improper predicate, is that Florida has tenancy by the entireties and Georgia doesn't. So what happens here in Georgia law is irrelevant.
I've already told you I'm going to take out Georgia.
I appreciate that, Your Honor.
Okay.
Unlawfully killed,
So you don't like the term unlawfully killed?
it is a misstatement of the law. The law says intentionally and unlawfully killed.
Well, but to say intentionally and unlawfully killed ignores the paragraph of the statute that Mr. J read that says any degree of murder constitutes intentional.
Your description includes manslaughter. Any degree of murder does not.
I don't disagree with you on that. I'm willing to clean it up. Now what we're discussing is what I'm going to do.
Well, I think I've made my argument, and I honestly think if you're concerned that Truitt is going to create reversible error and the state is going to appeal an acquittal based on that, that is not a concern.
I'm not aware of the state's ability to appeal an acquittal, so I'm not really concerned about that. However, the state is just as entitled to a fair trial as the defendant is.
Absolutely.
And if they are requesting a jury instruction that under Florida law should be given, I'm going to give the jury instruction.
If the facts support, the only way the facts support this jury instruction, because again, we're talking about motive and intent, and I won't say intent is an element of second-degree murder. Let's call it motive. And Your Honor asked me if we are not planning on arguing that Mr. Ward had no motive because it defeated a financial protection, and I said we are. As far as motive, we need to get in Mr. Ward's mind. The state has put in zero evidence that Mr. Ward had any awareness of this statute. And I understand the court's concern about clearing up a misstatement of law that a witness made, but a witness didn't make a misstatement of law about this. He said he'd never seen it, and he didn't know what it was. Unless there is some evidence connecting this to Mr. Ward and his knowledge, it is not supported by the facts, and the state, entitled to a fair trial as they are, is not entitled to this instruction.
Mr. Braven, you can't have it both ways. You can't argue that this goes to Mr. Ward's state of mind, even if he didn't know, and then say that the state isn't entitled to argue that this goes to Mr. Ward's state of mind. You're trying to have your cake and eat it too. You can't do that, all right? So we're at the point where, having read the Truitt case, having gone over my notes on Professor Davis's testimony, I think this is a proper statement of the law, except that I agree with you that the words unlawfully killed can be problematic, so we need to find a different way to word it. Over the defense's objections, I am going to read, when property is held as tenants by the entireties, the surviving party becomes the sole owner of 100% of the property upon the death of the other party. The second paragraph is the one that we're talking about right now. And by the way, just for the record, I noted that you were willing to have me read it as a stipulation, and the court sees no distinction between me reading it to the jury as a stipulation and me reading it as a jury instruction. So let's discuss the term unlawfully killed that comports with the statute. Yes.
I also object, the state also objects to saying, unless he is found,
The defense.
I'm sorry, excuse me, the defense also objects to the language, if a party is found to have, has anybody done any research on the standards that are applicable here, the burden of proof, this creating?
I can say if a party is convicted of murdering the other tenant by the entirety, all the property of the deceased party passes to their estate.
I
Judge.
understand.
Yes, sir.
Just to briefly interrupt on this one point.
Yeah.
Section 5 of that statute says, in its totality, instead of parsing out some of it, a final judgment of conviction of murder in any degree is conclusive for purposes of this section, period. Then it proceeds to say, in the absence of a conviction of murder in any degree, the court may determine by the greater weight of the evidence, which in Florida means preponderance, that the killing was unlawful and intentional for purposes of this section. So that's where it gets muddy, because it still goes to, it can be murder too, which doesn't require an intent to kill, or it can be a finding by the court under a preponderance of evidence.
So what's your proposed language? I think yours is too long and it places too much emphasis on this and it just parses it out. So.
Well, I don't want to keep beating the dead horse, but I think the white elephant in the room that nobody really wants to talk about, except for me, is that Mr. Gillen is the one who made some statements about the law in his opening statement that needs to be addressed. It's not just Professor Davis. The defense made a huge production that Mrs. Ward's life was like...
I'm going to read an instruction, Mr. J. I just need to narrow it down so that we don't spend 2 hours on this. I've ruled on it.
Okay.
It's coming in as an instruction. We're just working on the language at this point.
Your Honor, may I make a record? One more thing, please.
Yes, sir.
Mr. J said Mr. Gillen made a big point of it in opening. Mr. J also clearly knows the Florida statute, and yet this morning he said there's no possibility he could bring in any evidence or anybody to testify about the law. We put on a legal expert to talk about the law. Mr. J and the state had equal ability to put on an expert. This is not a surprise tactic. Mr. Gillen made a big point of it in opening. We've known about this for over a week. It could have been evidence. That is where it belongs. The other point about this is that, well, excuse me for a moment. I just want to know for the record, has anybody done any research about this statute to gain any further understanding of the statute?
All right, we're proceeding to the language of the statute. Anything else you want to put on the record, Mr. Braden?
No, Your Honor.
Thank you. We're proceeding to the language on the second paragraph.
As Your Honor has stated, I think simplifying it rather than being technically legal correct is what's proper for the jury. So I think the language of unlawfully killed is fine for their purposes. And this isn't the state's evidence. We're just rebutting what they said was a lack of motive.
All I'm doing is telling the jury what the law in Florida is on the issue of tenants by the entireties. That's all this jury instruction is meant to do. My reading of Truett is that the state is requesting it. They're entitled to it as long as it's a correct statement of the law. And I have already made a finding that the facts of this case support this reading, and I'm not going to argue about my ruling anymore. What do you all want the language of the second paragraph to say, Mr. J?
With the deletion of "and Georgia," then we're fine from the state's point of view.
Well, right now what I'm down to is if a party is found to have unlawfully killed the other tenant by the entireties, comma, all of the property of the deceased party passes to their estate and or heirs. I need to put a slash mark in there. and not to the surviving tenant by the entireties, period.
State agrees with that.
What's your proposed language?
So I proposed earlier this morning, quote, unless it is proven that the surviving party unlawfully and intentionally killed the decedent, after your first paragraph, that is, in which case only 50% of the property passes to the surviving spouse and 50% passes to the estate of the deceased.
What?
That was based on the first paragraph, which said when property is held as tenants by the entireties, the surviving party becomes the sole owner of 100% of the property upon the death of the other. Next paragraph, unless it is proven that the surviving party unlawfully and intentionally killed the decedent, in which case only 50% of the property passes to the surviving spouse and 50% passes to the estate of the deceased.
That sounded that sounds confusing when it's read out loud.
With all due respect, so does the other version.
Found to have unlawfully. I know you keep wanting to put the word intentionally in there, but the statute doesn't require that.
Your Honor,
The
if you want to say
statute,
murder,
second-degree murder does not require intentional killing.
understood, Your Honor, paragraph 5 of the probate statute, which we're talking about, says any degree of murder. This cannot include manslaughter. Your definition cannot mislead the jury into believing that if manslaughter is found, that this applies.
It actually does apply if a judge then makes a ruling, but I get what the point you're making.
but the
here
judge-
are your choices. If you want me to make it very clear as to this case, you get if a party is found to have murdered the other tenant by the entireties, all of the property of the deceased party passes to their estate and/or heirs. That's what you're asking me to read.
Can you read the standard of the burden of proof you read in that? I'm sorry.
If a party is found to have murdered the other tenant by the entireties, all of the property of the deceased party passes to their estate and/or heirs and not to the surviving tenant by the entireties.
No, we don't want that, Your Honor.
I didn't think you did.
So our problem here, again, is in trying to boil down this multi-paragraph law to one sentence. The statute itself says unlawfully and intentionally killed. Then in paragraph 5, it says that presumptively any degree of murder counts.
I could do if a party is found to have unlawfully and intentionally killed the other tenant by the entireties and put in parens any degree of murder qualifies. All of the property of the deceased party passes to their estate and/or heirs. That tracks the language and points out it's murder.
Over defense objection.
Oh,
We agree.
absolutely. I think the record is clear that you object.
In case anyone can't see
I
my
don't
face.
think that you've missed any point on that. All right. So, if a party is found to have unlawfully killed the other tenant by the unlawfully and intentionally, I'm sorry.
Thank you, Your Honor.
And then after God, I'm getting tired. Is it before the comma or after the comma? We would put any degree of murder applies or qualifies.
If you're putting in the parentheses, I think before.
It's before the comma. By the time lunch rolls around, I can barely spell. All of the property of the deceased party passes to their estate and/or heirs and not to the surviving tenant by the entireties. State, any objections to that?
I need to read it.
All right, I'm going to send it to you guys again. I'm going to save it and send it.
And just for the record, there's a case, Nunez versus Gonzalez, 2nd DCA 456, Southern 2nd 1336. Says the former wife's conviction upon her plea of guilty to manslaughter and killing her ex-husband could be introduced in her suit upon life policy, in which she was named as primary beneficiary as evidence of an intentional killing.
So whether it can be introduced is not about whether it is conclusive of the ultimate question.
I'm just attaching this without a note, since I'm sure you all know why I'm sending it to you.
No objection, Judge.
All right,
I have an objection, Your Honor.
which is?
One, there should be a space before the parentheses. That's not an objection, that's a
Oh,
note.
yeah, that's, I expect Mr. J to clean all that up, yeah.
The second portion says all of the property of the deceased passes to the party with tenancy by the entireties, as Professor Davis explained in laborious detail, all of that property is both of theirs. I believe it should say the deceased's portion of the property.
There is no portion to tenancy by the entirety.
It converts into a joint tenancy, and the 50% that is,
I know what you're telling me. You guys are getting into the minutia of complications where I'm going to be spending quite a bit of time reading a tenancy by the entireties instruction. If you wanted to say, if a party is found to have unlawfully and intentionally killed the other tenant by the entireties, parents, any degree of murder qualifies. What is it that you wanted to say? Then the deceased,
all of the property, the portion of the property,
I can say it becomes a tenancy in
Joint.
common. Ooh. Yeah. It's
joint
convert-
tenancy or tenancy at law?
It becomes a tenancy in common,
Yes, Your Honor.
and the property of the deceased party passes to their estate and their heirs? That's part of what you had in.
I would
The way we're
suggest,
going, we're going to go back to what he had.
I would suggest that my explanation is the best one that explains what happens to it without using words like tenancy in common.
So, and Mr. J's portion says 50% interest, which is why I use those terms, and Your Honor told me that it was confusing. If it says a 50% interest passes,
If you all want to go back to it reading as follows. Paragraph 1, when property is held as tenants by the entireties, the surviving party becomes the sole owner of 100% of the property upon the death of the other party. That is to clarify the misstatement of the law by Professor Davis. Then it would say, if a party is found to have unlawfully and intentionally killed the other tenant by the entireties, parents, any degree of murder qualifies. Then the tenancy by the entirety converts to a tenancy in common. And then we read out Mr. J's 3, he broke it out as to what Florida law is on this, which I was trying to avoid, but if you all want to do that, I'll do that.
and is it Your Honor's conclusion that my summary of that, which was 50% of the property passes to the surviving spouse and 50% passes to the estate of the deceased, is unclear in some way?
That isn't what you said the first go around.
Well, I said a bunch of stuff before that, but, okay, so I would ask.
You know what? Why don't you and Mr. J talk to one another and see if you can come up with something you can agree on for a minute. In terms of that, at this point, I'm almost back to Mr. J spreading it out like that, which is what I was trying to avoid. So go ahead. Did that help?
Yes, Your Honor.
Have you guys reached a conclusion? An agreement, so to speak?
Yes, but
Would someone like?
You
You
wanna-
can't type it. Go ahead.
I was going to send it to both of you, but and use the judge's first paragraph if you want.
You ready, Mr. J?
Yes, ma'am.
All right. Have you all reached a final version? Can you send me the final version of the jury instructions so I can do the full charge conference, please?
Your Honor, we have one more jury instruction point.
Yes, sir.
I understand earlier in the first preliminary charge conference, there was an indication from defense that we were not requesting the circumstantial evidence instruction, and the defense isn't requesting the circumstantial evidence instruction that was given in the first case.
Is or is?
Is requesting the circumstantial evidence instruction that was given in the first case.
State.
Objects.
Find it. What's the state's objection?
It's not needed. The Florida Supreme Court got rid of it for a reason.
Yeah. Is there something about that instruction? It's not normally given anymore, So, if you could just make a record for me on why you're asking for it?
Yeah, yes, Your Honor, it's a discretionary instruction. It was given in the first case. We're asking for it because the state's case here is entirely circumstantial, and this is the state of the law, and we'd ask that the jury be instructed on the complete state of the law.
I have to find it. Yeah, the Supreme Court got rid of this instruction. I forgot the case. Anybody know the case site?
Your Honor, I know it was in 1981, so there was an amendment to the rules, and they took it out of the standard jury instructions, and it remains a special jury instruction that can be given at the court's discretion when the facts apply.
No, I know that. That wasn't really the question. I wasn't very clear on what I was asking.
Well, the case that you might want to look at is at 134 Southern 3rd, 492. I'm not even going to touch that last name. But Head Note 18 is exactly on point.
There's been some subsequent litigation on this issue, so I'll give you time to look at that case also.
Could you restate the
I
site?
vaguely remember it. 134
Yep.
Southern 3rd,
Yep.
492.
Yes, at Keynote 18, it says, finally, we reject appellant's argument that the trial court abused its discretion in refusing to instruct the jury on the state's burden of proof in circumstantial evidence cases. The Florida Supreme Court has consistently held that it is within the trial court's discretion to refuse to give the circumstantial evidence instruction, comma, which was removed from the standard jury instructions over 30 years ago. Citing, citing, citing.
Your Honor, that's the law that I'm familiar with and that we cited, that it is no longer required as part of the standard jury instruction, but it's discretionary and that it can be given when it's appropriate, and we're requesting that you give it in this case, please, as they did in the first case.
What I'm actually looking at right now is, I'm not going to attempt to pronounce this name, but it's GOSCIMINSKI versus State. 132 Southern 3rd, 678. It's a Florida Supreme Court case, 2013, containing a discussion of the circumstantial evidence rule, or the circumstantial evidence instruction. My apologies.
We had agreed that the law pertaining in 2009 was going to apply, and I understand this may comment on whatever that law was, but we're putting ourselves back in September 21st, 2009, accurate?
Right. I'm going backwards in the Supreme Court cases on this.
Thank you, Your Honor.
That's what I'm trying to do. See, because they truly, the courts in Florida have moved away from giving that instruction. It is contained in the reasonable doubt instruction. That is what the Supreme Court has pretty uniformly ruled.
And yet the court gave it in 2011 in September in this case and wasn't reversed or wasn't cross-appealed by the state.
Because it's discretionary. You don't get reversed for giving it.
I understand, and that's why we're asking that you exercise your discretion in order to give it.
Right. Let me look and see. I'm not inclined to give the instruction. The courts really have moved away from giving it. There was a reason for that. I do think it's contained within the reasonable doubt. And certainly the defense can argue it to their heart's content. The law on circumstantial evidence, you can argue. All right.
Understood.
So, anything else?
Is this an appropriate time to renew our JOA?
Let me finish the jury instructions and then we'll
Yes,
do
ma'am.
that. Because Mr. J's got to do some typing and printing and all that. So, and then we'll do the JOA motion. Mr. J, any other changes that is being requested by anyone? Can I see the final version so that we can go through the charge conference, please? All right, I've gotten the final version. Have you, Mr. Braden?
Yes, Your Honor.
Okay. All right, beginning at introduction to final instructions. Any objections from defense?
Are we going to go over the as applicable? Are we going to make them final now? Excuse me.
That's why I'm going through them, to see if there's any other objections, in
Well,
which case I'll declare them final.
There's still language in here from the jury instruction, give in certain cases, give if defendant, they're not in a form that is.
Well, when we get to them, then we can
Yes, Your Honor,
address
we'll
them.
state our objections as we go.
Yes.
Thank you, Your Honor.
All right, introduction to final instructions. Any objection?
No, Your Honor.
Statement of charge. Any objections?
No, Your Honor.
Introduction to homicide.
No, Your Honor.
None? Okay. Justifiable homicide.
No.
Excusable homicide. Up to murder.
Understood. No objection, Your Honor.
All right. Count one, murder, second degree. Any objections?
No, Your Honor.
Aggravation of a felony by carrying a firearm.
No objection.
You can sit during this, Mr. Braven.
Thank you, Your
don't
Honor.
have to be Sitting up, I appreciate it, but possession of a firearm and discharge causing death.
No objection.
Lesser included crimes or attempts. The category 1 manslaughter with a firearm is the lesser included.
No objection, Your Honor.
So you're not objecting, I wasn't clear in my question, which is why I'm clarifying. You're not objecting to the manslaughter instruction.
We object neither to giving it nor the text of it.
All right, thank you. Aggravation of a felony by carrying a firearm as to manslaughter.
No objection, Your Honor.
Justifiable use of deadly force as to manslaughter.
Defense has no objection.
Tenancy by the entireties. Any additional objections to that instruction?
Your Honor, may I go back to the justifiable use of deadly force, please?
As to manslaughter? There's two of them, so I need to know which one you're talking about.
No, Your Honor, there's only one section of
I'm sorry, you're
justifiable
right.
use of deadly force.
Justifiable homicide. Okay, go ahead. Justifiable use of deadly force. Go ahead.